A durable power of attorney is sometimes referred to as just a power of attorney or a financial power of attorney. It's a pretty simple legal document that you sign now as the principal, you being the principal, and you designate another person called your agent to act on your behalf with respect to financial matters if you would become incapacitated. There's two different ways to draft up a power of attorney. One is called springing and one is called immediate. A springing power of attorney does not go into effect until you become incapacitated. So the document would say, once I am incapacitated in the opinion of 2 doctors, then my agent, who I have picked, will step up and take care of my financial affairs for me. And if you're a married couple, I typically do powers of attorney so that they're effective immediately, so that if one of you becomes incapacitated, the other of you doesn't have to go get a doctor's report in order to start acting under the power of attorney. The powers of attorney always list what powers the agent has, which is very important. By statute, we need to list the specific powers so that they're able to handle your bank accounts, deal with the Social Security office, file your income tax return, all of these financial matters that you take for granted that you can do for yourself. That document kicks in your incapacity and allows others to do those for you. The whole purpose of doing the durable power of attorney is to avoid what I call living probate. Living probate is guardianship and conservatorship monitored by the probate court. So if you become incapacitated and you don't have a power of attorney in place, your family may need to petition the probate court to be appointed your guardian and or conservator, which is a very lengthy, expensive, and painful process. So a durable power of attorney is a really good way to avoid that. One of the most common mistakes I see people make is they fear, well, what if something happens to me and my kids need access my bank account right away? So they've added their children to their bank accounts, and that is not a good decision. If you have your children listed with you on your bank account and they get sued or go through a divorce or have some sort of accident, your assets may be exposed to their risks. They also have no fiduciary duty to spend that money on your behalf, whereas in a power of attorney document, the agent is required to handle your financial affairs with regard to you and what's in your best interest. Also, obviously, if you add your children to your bank account, they can walk in at any moment and take the money. And also, after you pass away, all of the funds in that account would go to the child that you have on the account. And if there's more than one child listed, whoever the first one to the bank is would get the money. So it may not pan out the way you want it to if you wanted it divided equally among your children. Also, just by adding your children to your bank account, that doesn't give them the power they need to manage your other financial assets. For example, filing your tax return, calling the Social Security office, dealing with your benefits through work, or any other financial matters that the power of attorney would cover.